Hello everyone, my name is Rupa Singh and welcome to this video. And today we are going to talk about the EU AI Act, how EU is setting the global standards for AI, objective of EU AI Act, EU's global influence and race to the top, and shaping governance for tomorrow's innovation, the Brussels effect, the de jure effect, and will we see a Brussels effect in the world of AI? So don't go anywhere, stay tuned to the end, and we'll dive deep into the EU AI Act. The European Union has taken a significant step forward in shaping the future of artificial intelligence with the passing of the new EU-AI Act in the European Parliament on Wednesday, 13th of March 2024, with an overwhelming 523 votes in favor, and which signals a commitment to shaping the future of AI in Europe and beyond. Well, EU is setting the global standards for AI. Taking a strong stance on regulating AI products and services before they can access the EU market. And EU demonstrate courage, innovation, and strong leadership to legislate through the complex and interdisciplinary field of AI regulation. And EU always has a track record of setting global standards in the area of technology and regulation. And the GDPR, which has become a blueprint for privacy, data protection, and data sovereignty, serves as an example of how EU's approach to regulation can have significant impact beyond its borders. So the legislation would oblige companies from other countries such as US and China to conform to EU standards based on ethical values before their AI products and services can be introduced to the vast European market, whether it's around 450 million consumers. And as a consequence, the regulation would have a global impact since it has extraterritorial reach, applying not just to EU companies, but also to international companies that want access to EU market. And by embedding EU norms and values into the infrastructure of AI technology, the EU is setting a direction for the rest of the world to follow. Well, EU is at the forefront of creating new global standards and taking a leadership role in shaping the development and regulation of AI technology with its recent EU AI Act, ensuring that AI can be relied upon following the introduction of these groundbreaking regulations. Objective of EU AI Act, which is to ensure that the AI systems placed on union market and used are safe and respect existing law on fundamental rights and union values. Ensure legal certainty to facilitate investment and innovation in AI, and enhancing governance and effective enforcement of existing law on fundamental rights and safety requirements applicable to AI systems, and facilitating the development of a single market for lawful, safe, and trustworthy AI applications and prevent market fragmentation. Well, EU's influence to the race to the top. EU's global influence, the gold standard for regulation, and the race to the top. Well, EU rules have shaped policy development in areas outside Europe, resulting in Europeanization of numerous norms across the globe. And this effect is measured not in terms of legislative change, but also how the corporate boardrooms across the globe view EU rules as the gold standard to guide or otherwise shape their behavior. And the GDPR is a prominent example when it comes to force. It had a far-reaching implications for companies around the world that process the data of EU citizens. And GDPR in 2016 and DPD, that is Data Protection Directive in 1995, have not only raised the bar for privacy and data protection, but also exemplified how EU legislation can influence global regulatory practices and standards. And this stands as a counter narrative to the argument that globalization leads to overall relaxation of regulatory standards or a race to the bottom, where multinational companies seek out jurisdictions with the least stringent regulations to maximize profit. Now, Brussels effects suggest that in certain cases, race to the top can occur instead, where companies and countries compete to meet higher standards. And this dynamic can lead to improved global practices. And it is also a testament to the power of market forces to drive regulatory standards, as well as the influence of governance in shaping international norms and best practices. So, how does EU shape governance for tomorrow's innovation? Well, because of the rapid growth of technological advancement and innovation, governance and regulatory mechanisms are put to the test, and new and innovative regulatory mechanisms are essential to enable governments to successfully integrate these technologies into our societies to ensure that it is integrated in a sustainable, beneficial, and just manner. Well, among many innovations under scrutiny, artificial intelligence stands out as one of the most debated of such innovations, and questions such as what exactly AI is and who should it be, how should it be constructed, how should it be used, and whether it should be regulated or not. And these questions are becoming central to our discussions as these debates continue. AI is finding widespread use within a spectrum of regulatory contexts, which encompasses established frameworks, evolving paradigms, and tailored regulations specially designed for AI. Now, catalyzing change, the EU AI Act and the global discourse on transparency and accountability. Well, if the GDPR created a global conversation about privacy and the protection of personal data, then it is safe to say that EU AI Act is poised to spark a similar discourse around transparency and accountability of AI systems and platforms. Well, EU's proactive stance on regulating AI deserves credit for being the first among international political organizations or states to propose a regulatory framework for updating AI systems. And tackling such a task is no small feat, and especially considering the complex and multifaceted nature of AI technologies. And by insisting that this framework be rooted in European values and fundamental rights, the EU setting high global standard, much like it did with the GDPR and privacy rights. So why is this important? Well, imagine that this framework achieves for concepts like AI transparency and trustworthiness what the GDPR did for privacy. Well, it could be a game changer on a global scale, setting a gold standard for responsible AI development. Now, let's rewind to 2018 when EU Commission published its Artificial Intelligence for Europe strategy. And this document laid out a series of steps to address public concerns, fill liability gaps, and support AI startups. So the message that the EU won't leave anyone behind, emphasizing the values such as privacy, trust, and ethics. Now, the Brussels effect. So are we going to see the Brussels effect? Well, the term Brussels effect refers to the phenomenon where regulations and standards set by the European Union have a significant influence beyond its borders and shaping policies and practices in other jurisdictions. And this influence can occur both formally, that is de jure, and through direct adoption of EU regulations by other countries, and informally, that is de facto, through market dynamics and the desire to access the EU market. So let's consider the de jure effect. Now, if a company formally adopts regulations according to EU AI Act, it would constitute a de jure effect. And this could involve enacting laws or regulations mirroring the provisions set forth in the EU legislation. So, for example, a country outside EU explicitly incorporates the requirements for high-risk AI systems as defined in the EU AI Act for its own national legislation. Now, a de jure effect, Brussels effect, is also likely for parts of the EU's AI regulation. But EU has relatively favorable market properties, and in particularly, the market for AI product is large and heavily serviced by multinational firms. So what's intriguing about EU market is how its size serves as a catalyst for innovation and compliance. And the sheer scale of market incentives uh, incentivizes firms to invest in developing and offering products that adhere to EU regulations. So rather than opting out of the EU market due to regulatory complexities, companies are motivated to adapt and comply and ensuring that their products meet the standards set forth. So here is where it gets even more interesting. So many of these multinational firms don't just operate within the EU boundaries, they also have significant presence in non-EU markets. And this dual presence creates a fascinating ripple effect. Well, by serving both EU and non-EU markets, these companies inadvertently set a standard. The products they develop and sell in compliance with EU regulations often become a de facto benchmarks for quality and standards in other regions as well. So, well, de jure effect would mean that other jurisdictions formally adopt regulations similar to those set by the EU. And there are several reasons why this might happen. The first one is the quality and consistency. Well, foreign jurisdictions may view EU regulations as high quality and consistent with their own regulatory goals, leading them to adopt similar rules for their own sectors. Now, EU promotion. Well, EU actively promotes its regulatory blueprint through participation in international institutions and negotiations, encouraging other countries to follow suit. Market incentives. Well, de facto Brussels effect occurs when jurisdictions recognize that aligning with EU regulations reduces burden on companies operating in both markets, and this can incentivize them to adopt similar regulations to maintain market access. The active incentives, well, the EU may actively incentivize the adoption of its regulations through trade rules or other mechanisms. Well, the likelihood of de jure diffusion is higher for jurisdiction with significant trade relations with the EU, and introducing regulations incompatible with EU standards could create trade frictions, motivating these countries to align their regulations with those of the EU to facilitate trade. Now, furthermore, the requirements set by the EU AI Act for high-risk systems may become the international gold standards for responsible AI development and deployment. And this could further drive other jurisdictions to adopt similar regulations to enhance trust and compatibility in the global AI market. Various high-risk users of AI that are listed as part of Annex 3 of the AI Act, with a particular focus on the category related to employment, work management, and access to self-employment opportunities. And here is an example of each aspect. So that is remote biometric identification and categorization. And this refers to the AI systems, the use of AI systems to remotely identify individuals based on biometric data such as facial recognition technology. And it is a high risk application due to privacy concerns and potential misuse. Now, admission or grading in education. AI systems used for admission processes or grading students in educational institutions. Well, this could involve automated grading of exams or evaluating students' applications, which can have significant implications for individuals' academic opportunities. Then the management and operations of critical infrastructure. AI applications involved in managing and operating essential infrastructure systems such as transportation networks, energy grids, and water supply systems. And the reliability and security of these systems are critical for public safety and national security. Now, the law enforcement. Well, AI systems used in law enforcement activities such as predictive policing, algorithms, or facial recognition technology for surveillance purposes. The use of AI in law enforcement raises concerns about bias, privacy infringement, and potential abuses of power. Now, employment and worker management. Well, this category encompasses a wide range of AI applications related to employment practices and workforce management. It includes gig economy platforms such as ride-hailing services, Uber and Bolt, and delivery companies, example, Deliveroo or Foodora, and freelancing platforms such as Fiverr and TaskRabbit. And additionally, it may apply to software solutions for staff scheduling and hiring, known as workforce management systems. And these applications involve significant human impact, including employment opportunities, working conditions, and job security, making them high risk from a societal perspective. Now, the risk categorization. Well, EU AI Act includes a risk-based approach to the regulation of AI systems. The proposed framework consists of 4 risk tiers, that is unacceptable risk, high-risk AI systems, limited risk, and minimal risk. And these risks are classified based on the potential risk that AI systems poses on health and safety of fundamental rights of individuals. And the risk classification systems are designed to ensure that the level of regulation and oversight is commensurate with the level of risk posed by a particular AI system. And AI systems that pose an unacceptable risk to human health and safety of fundamental rights would be prohibited under the proposed regulations. So under unacceptable risk, the scope is the subliminal techniques or exploiting vulnerabilities of specific populations which cause harm. Social scores used by public authorities or on their behalf, and the real-time remote biometrics in public spaces used by law enforcement, with some exceptions. And the requirements are that these uses are prohibited. The sanctions is fines up to 6% of global revenue or 30 million euros, whichever is higher. Now, high-risk AI systems are the AI systems that are products or safety components of products, including medical devices, toys, and machineries, and remote biometric identification and categorization of natural persons. That is, for example, a system classifying the number of people of different skin tones walking down a street. The management and operation of critical infrastructure, for example, road traffic and the supply of water, gas, heating, and electricity. Now, education and vocational training, where systems are used for admission and grading, employment, worker management, and access to self-employment opportunities, including systems that make or inform decisions about hiring, firing, and task allocation, access to and enjoyment of essential private services and public services and benefits, and specific uses of law enforcement, specific uses in migration, asylum, and border control management, and administration of justice and democratic processes, in particular when used to research and establish facts or applying the law to some facts. Now, what are the sanctions for high-risk AI systems are that fines up to 4% of global revenue or 20 million euros, whichever is higher for everything except the data requirements, where the same fines apply as for the prohibited systems. Now, limited risk. The scope of the limited risk of are the AI systems which interact with natural persons, emotions, recognition systems, or biometric categorization systems, and AI systems that generates or manipulates image, audio, or video content that appears real. And the sanctions for limited risk is fines up to 4% of global revenue or 20 million euros, whichever is higher. And the category 4, which is minimal risk, scope for these systems are all AI systems that are not either prohibited or high risk. And requirements are that providers can choose to comply with voluntary codes of conduct, and the Commission and member states will encourage the creation and voluntary compliance with these codes. And for the minimal risk, there's no applicable sanctions as there are no requirements. So will we see a Brussels effect in the world of AI regulation? But first, what exactly is Brussels effect? Well, think of it as the EU's regulatory influence extending beyond its borders. It's about the spread of EU standards and norms, not just through market forces, but through various channels and to varying degrees. Now, let's clarify a few things. When we talk about Brussels effect, we're not just talking about a one-size-fits-all phenomenon. It is not about just whether other countries adopt EU regulations wholesale or not. Well, we are looking at degrees of diffusion here, and this legislation is a game changer in the world of AI governance, aiming to set standards for ethical and responsible AI development and deployment. So let's explore the various degrees of diffusion in the context of EU AI Act. And the first one is the full adoption. Well, imagine a non-EU country decides to fully adopt the EU AI Act as its own national legislation. And this country directly incorporates all the provisions, requirements, and standards outlined in the EU AI Act into its own legal framework without any significant modifications. Now, partial adoption. Another scenario involves a non-EU country that decides to partially adopt EU AI Act. While it incorporates many aspects of the EU regulations, it may choose to modify certain provisions to better suit its own legal and cultural or economic context. For instance, the country might retain the core principles of transparency and accountability, but adjust the threshold for defining high-risk care systems to align with its own risk assessment framework. Now, harmonization. Now, consider a group of countries outside the EU that are members of a regional trade bloc. In order to facilitate trade and ensure regulatory coherence, these countries collectively develop AI regulations that are harmonized with the EU AI Act. While each country maintains its own sovereignty, the regulations are designed to be consistent with EU standards to promote interoperability and ease of compliance for companies operating in both regions. And then convergence. Well, over time, multiple jurisdictions around the world start to converge on regulatory standards for AI that are similar to those outlined in the EU AI Act. And this convergence may occur through international collaboration, alignment with global best practices, or the influence of international standard setting bodies. While not directly adopting EU regulations, these jurisdictions develop their own framework that share common principles and objectives with the EU AI Act. Now, adaptation. A country in a different region decides to adapt certain provisions of the EU AI Act to better suit its own legal systems and cultural values. Now, for example, it may retain the requirements for transparency in AI decision making, but modify the mechanisms for enforcement to align with its own administrative and judicial processes. Now, this adaptation ensures that regulations are effective and enforceable within the local context. Now, inspiration. Well, even in regions where EU AI Act is not directly applicable, policymakers may be inspired by its principles and objectives when developing their own AI regulations. For instance, a country in Asia may develop their own regulatory framework for AI governance and drawing on the principles and on the transparency and accountability requirements outlined in the EU AI Act as guiding principles. So while not directly aligning with EU regulations, this framework reflects a shared commitment to responsible AI development and deployment. Well, thank you for watching this video, and I hope you find this video useful. If you like this video, please do subscribe to my channel for more such videos and updates. Thank you. Take care.